Welcome to our annual training on sexual harassment prevention. In recent years, the topic of sexual harassment in the workplace has been brought into the national spotlight, bringing with it renewed awareness about the seriousness and unacceptable nature of these actions and the severe consequences that follow. The term sexual harassment may mean different things to different people depending on your life experience. Just because you think certain conduct is acceptable or was acceptable in the past does not mean it is currently acceptable to people you work with. The purpose of this training is to set forth a common understanding about what is and what is not acceptable in our workplace. New York State has long been committed to ensuring that all individuals have an equal opportunity to enjoy a fair, safe, and productive work environment. Laws and policies help to ensure that diversity is respected and that everyone can enjoy the privileges of working in New York State. Preventing sexual harassment is critical to our continued success. Sexual harassment will not be tolerated. This interactive training will help you better understand what is considered sexual harassment. It will also show you how to report sexual harassment in our workplace, as well as your options for reporting workplace sexual harassment to external state and federal agencies that enforce anti-discrimination laws. Let me assure you that these reports will be taken seriously and promptly investigated with effective remedial action taken where appropriate. Harassment is a form of discrimination that consists of words, signs, jokes, pranks, intimidation, physical actions, or violence that is directed at an employee due to any protected characteristic. These include race, age, creed, color, national origin, sexual orientation, military status, sex, disability, marital status, domestic violence victim status, gender identity, and criminal history. Harassment includes offensive behavior based on stereotypes about a protected class and behavior that is intended to cause discomfort or humiliation because of a protected characteristic. It also includes any expression of contempt or hatred for the group to which the victim belongs based on a protected characteristic. We have a zero tolerance policy toward harassment. Any harassing behavior will be investigated and the perpetrator or perpetrators will be told to stop. Disciplinary action will be taken if appropriate. If the behavior is sufficiently serious, disciplinary action may include termination. Repeated behavior, especially after an employee has been told to stop, is particularly serious and will be dealt with accordingly. Sexual harassment is a particular type of harassment and a particular type of sex discrimination. Sex discrimination in general includes any type of bias based on sex, sexual harassment, sex stereotyping, discrimination on the basis of gender identity or the status of being transgender. What is sexual harassment? Sexual harassment is defined as any unwanted verbal or physical advance, sexually explicit or derogatory statement, or sexually discriminatory remark that is offensive or objectionable to the recipient or which interferes with his or her job performance. Here are two main types of sexual harassment. Hostile environment. A hostile environment on the basis of sex may be created by words, signs, jokes, pranks, intimidation, physical actions or violence, either of a sexual nature or not of a sexual nature, directed at an individual because of that individual's sex. Hostile environment sexual harassment includes sexual or discriminatory displays or publications anywhere in the workplace, such as displaying pictures, posters, calendars, graffiti, objects, promotional material, reading materials, or any other materials that are sexually demeaning or pornographic. This includes such sexual displays on workplace computers or cell phones and sharing such displays while in the workplace. Hostile actions taken against an individual because of that individual's sex, such as interfering with, destroying or damaging a person's workstation, tools or equipment, or otherwise interfering with the individual's ability to perform the job. Sabotaging an individual's work, bullying, yelling, name-calling. Quid pro quo sexual harassment. Quid pro quo sexual harassment occurs when a person in authority trades or tries to trade job benefits for sexual favors. Quid pro quo is a legal term meaning trade. This type of harassment occurs between an employee and someone with authority, like a supervisor who has the ability to grant or withhold job benefits. Quid pro quo sexual harassment includes offering, or granting better work conditions or opportunities in exchange for a sexual relationship, threatening adverse working conditions like demotions, shift alterations or working locations, or denial of opportunities if a sexual relationship is refused, using pressure, threats, or physical acts to force a sexual relationship, retaliating or refusing to engage in a sexual relationship. Sexual harassment can occur between males and females or between persons of the same sex. The term sex includes sexual orientation, gender identity, and the status of being transgender. Sexual harassment that occurs because the victim is transgender is also unlawful. The law protects employees, unpaid interns, and non-employees who work in the workplace, including independent contractors and those employed by companies contracting to provide services in the workplace. The perpetrator of sexual harassment can be anyone in the workplace. The harasser can be a coworker of the recipient. The harasser can be a supervisor or a manager. The harasser can be any third party, including a non-employee, intern, vendor, building security, client, customer, or visitor. Harassment can occur whenever and wherever employees are fulfilling their work responsibilities, including in the field, at any employer-sponsored event, trainings, conferences open to the public, and office parties. Employee interactions during off hours, such as at a hotel while traveling or at events after work, can have an impact in the workplace. Locations off-site and off-hour activities can be considered extensions of the work environment. Harassing behavior that in any way affects the work environment is rightly the concern of management. Sex stereotyping occurs when conduct or personality traits are considered inappropriate simply because they may not conform to other people's ideas or perceptions about how individuals of either sex should act or look. Harassing a person because that person does not conform to gender stereotypes as to appropriate looks, speech, personality, or lifestyle is sexual harassment. Harassment because someone is performing a job that is usually performed or was performed in the past, mostly by persons of the opposite sex, is sex discrimination. Any employee who has engaged in protected activity is protected by law from being retaliated against because of that protected activity. Protected activities with regard to harassment include making a complaint to a supervisor, manager, or another person designated by your employer to receive complaints about the harassment, making a report of suspected harassment even if you're not the recipient, filing a formal complaint about harassment, opposing discrimination, assisting another employee who is complaining of harassment, providing information during a workplace investigation of harassment, or testifying in connection with a complaint of harassment filed with a government agency or in court. Retaliation is any action taken to alter an employee's terms and conditions of what employment, such as a demotion or sudden work schedule or location change, because that employee engaged in any of the above protected activities. Such individuals should expect to be free from any negative actions by supervisors, managers, or the employer motivated by these protected activities. Retaliation can be any such negative action taken by the employer against the employee that could have the effect of discouraging a reasonable worker from making a complaint about harassment or discrimination. The negative action need not be job-related or occur in the workplace, and may occur after the end of employment, such as unwarranted negative reference. A negative employment action is not retaliatory merely because it occurs after the employee engages in protected activity. Employees continue to be subject to all job requirements and disciplinary rules after having engaged in such activity. In order to establish a claim of retaliation, an individual must be able to show that the adverse action was motivated by the protected activity. Supervisors and managers are held to a high standard of behavior. This is because they are placed in a position of authority by the employer and must not abuse that authority. Their actions can create liability for the employer without the employer having any opportunity to correct the harassment. They are required to report any harassment that is reported to them or which they observe. They are responsible for any harassment or discrimination that they should have known with reasonable care and attention to the workplace for which they are responsible. They are expected to model appropriate workplace behavior. Supervisors must report any harassment that they observe or know of, even if no one is objecting to the harassment. If a supervisor or a manager receives a report of harassment or is otherwise aware of harassment, it must be promptly reported to the employer without exception. Even if the supervisor or a manager thinks the conduct is trivial, even if the harassed individual asks that it not be reported, supervisors and managers will be subject to discipline for failing to report suspected sexual harassment or otherwise knowingly allowing sexual harassment to continue. Supervisors and managers will also be subject to discipline for engaging in any retaliation. We cannot stop harassment in the workplace unless management knows about the harassment. It is everyone's responsibility. You are encouraged to report harassment to a supervisor, manager, or another person designated by your employer to receive complaints, as outlined in our sexual harassment prevention policy, so the employer can take action. Behavior does not need to be a violation of law in order to be a violation of the policy. We will provide you with a complaint form to report harassment and file complaints, but if you are more comfortable reporting verbally or in another manner, we are still required to follow the sexual harassment prevention policy by investigating the claims. If you believe that you have been subjected to sexual harassment, you are encouraged to complete the complaint form and submit to Human Resources or your manager. Once you submit this form or otherwise report a complaint, our organization must follow its sexual harassment prevention policy and investigate any claims. You should report any behavior you experience or know about that is inappropriate, as described in this training, without worrying whether or not it is unlawful harassment. Individuals who report or experience harassment should cooperate with management so a full and fair investigation can be conducted and any necessary corrective action can be taken. If you report harassment to a manager or supervisor and receive an inappropriate response, such as being told to just ignore it, you may take your complaint to the next level as outlined in our policy under legal protections and external remedies. Anyone who engages in sexual harassment or retaliation will be subject to remedial and/or disciplinary action up to and including termination. All employers must investigate all reports of harassment, whether information was reported in verbal or written form. An investigation of any complaint should be completed within a reasonable time frame, for example, within 30 days. The investigation will also be confidential to the extent possible. Any employee may be required to cooperate as needed in an investigation of suspected sexual harassment. It is illegal for employees to participate in any investigation to be retaliated against. Our organization also has a duty to take appropriate steps to ensure that harassment will not occur in the future. Here's how we will investigate claims. The Human Resources Department will conduct an immediate review of the allegations and take any interim actions as appropriate. Relevant documents, emails, or phone records will be requested, preserved, and obtained. Interviews will be conducted with parties involved and witnesses. Investigation is documented as outlined in the sexual harassment policy. The individual who complained and the individuals accused of sexual harassment are notified of final determination and that appropriate administrative action was taken. Workplace harassment can be based on other things, and it is not just about gender or inappropriate sexual behavior in the workplace. Any harassment based on a protected characteristic, like race or ethnicity, is prohibited in the workplace and may lead to disciplinary action against the perpetrator. Much of the information presented in this training applies to all types of workplace harassment. After this training, all employees are and should understand what we have discussed, including how to recognize harassment as appropriate workplace behavior, the nature of sexual harassment, that harassment because of any protected characteristic is prohibited, the reasons why workplace harassment is employment discrimination, that all harassment should be reported, that supervisors and managers have a special responsibility to report harassment. Let's take a look at a few scenarios that can help explain the kind of behaviors that can constitute as sexual harassment. These examples describe inappropriate behavior in the workplace that will be dealt with by corrective action, including disciplinary action. Remember, it is up to all employees to report inappropriate behavior in the workplace. Lee Yan's coworker, Ralph, has just been through a divorce. He drops comments on a few occasions that he is lonely and needs to find a new girlfriend. Lee Yan and Ralph have been friendly in the past and have had lunch together in local restaurants on many occasions. Ralph asks Lee Yan to go on a date with him, dinner and a movie. Lee Yan likes Ralph and agrees to go out with him. She enjoys her date with Ralph but decides that a relationship is not a good idea. She thanks Ralph for a nice time, but explains that she does not want to have a relationship with him. Ralph waits 2 weeks and then starts pursuing Lee Yan for more dates. She refuses, but Ralph does not stop. He keeps asking her to go out with him. Question 1. When Ralph first asked Lee Yan for a date, was this sexual harassment? True or false? False. Ralph's initial comments about looking for a girlfriend and asking Lee Yan, a coworker, for a date are not sexual harassment. Even if Lee Yan had turned Ralph down for the first date, Ralph had done nothing wrong by asking for a date and making occasional comments that are not sexually explicit about his personal life. Question 2. Lee Yan cannot complain of sexual harassment because she went on a date with Ralph. True or false? False. Being friendly, going on a date, or even having a prior relationship with a coworker does not mean that a coworker has the right to behave as Ralph did toward Lee Yan. She has continued working with Ralph, and he must respect her wishes and not engage in behavior that has now become inappropriate for the workplace. Lee Yan complains to her supervisor, and the supervisor, as required, reports her complaint to the person designated by her employer to receive complaints. Ralph is questioned about his behavior and he apologizes. He is instructed by the designated person to stop. Ralph stops for a while, but then starts leaving little gifts for Lee Yan on her desk with accompanying love notes. These love notes are not overtly offensive, but Ralph's behavior is starting to make Lee Yan nervous, and she is afraid he may start stalking her. Question 3. Ralph's subsequent behavior with gifts and love notes is not sexual harassment because he has stopped asking Lee Yan for dates as instructed. He is just being nice to Lee Yan because he likes her. True or false? False. Lee Yan should report Ralph's behavior. She was entitled to have effective assistance in getting Ralph to stop his inappropriate workplace behavior. Because Ralph has turned into pestering Lee Yan after being told to stop, he could be subject to serious disciplinary action for his behavior. Example 2. Sharon transfers to a new location with her employer. Her new supervisor, Paul, is friendly and helps her get familiar with her new job duties. After a few days, when no one else is around, Paul comes over to Sharon's work area to chat. Paul chats about what he did last night, which was go to a strip club. Sharon is shocked that Paul would bring up such a topic in the workplace and says nothing in response. Paul continues talking and says that all women in the office are so unattractive that he needs to go out and see some hot chicks once in a while. He tells Sharon he is glad she joined the staff because, unlike others, she is easy on the eyes. Sharon feels very offended and demeaned that she and the other women in the workplace are being evaluated on their looks by their supervisor. Question 1. Because Paul did not tell Sharon that she is unattractive, he has not harassed her. True or false? False. Paul has made sexually explicit statements to Sharon which are derogatory and demeaning to Sharon and her female coworkers. It does not matter that Paul supposedly paid Sharon a compliment. The discussion is still highly offensive to Sharon, as it would be to most reasonable persons in her situation. Question 2. By bringing up his visit to the strip club, Paul is engaging in inappropriate workplace behavior. True or false? True. Simply bringing up a visit to the strip club is inappropriate in the workplace, especially by a supervisor, and it would be inappropriate for Sharon to report this. It would be appropriate for Sharon to report this conduct. A one-time comment about going to a strip club is behavior that Paul would be told to stop, even though it probably would not rise to the level of unlawful harassment, unless it was repeated on multiple occasions. Question 3. Paul should be instructed to stop making these comments, but this is not a serious matter. True or false? False. Paul's comments about the female employees are a serious matter and show his contempt for women in the workplace. Paul is required to model appropriate behavior and must not exhibit contempt for employees on the basis of sex or any protective characteristic. Sharon should not have to continue to work for someone she knows harbors such contempt for women, nor should the other employees have to work for such a supervisor. Management should be aware of this, even if the other employees are not, and Paul should be disciplined and most likely removed from his current position.